Okay, so property and debt is different than all of the other areas because you have to be a spouse in order to be entitled to property and debt division under the Family Law Act, and there are no exceptions. So if you're under that 2-year mark, you are not entitled to property and debt division. One thing I should mention about the 2 years is that for married spouses, the date that your property becomes family property is not actually the date that you are married, it's the date that you started living together. So that's a common misconception among people. And for cohabiting couples, once you have been living together for 2 years, the 2-year period kicks back to the start of your relationship when you started living together. So it doesn't just start from the time that you've been living together for 2 years. Once you hit that 2-year mark, the 2 years before that is considered the start of your relationship. Does that make sense? Okay. Sorry, okay, so yes, I'll repeat. So if you have been living with someone for 2 years, once you hit that 2-year mark, the start date of your relationship is when you first started living together. So for example, if I hit the 2-year mark if I start living with someone today, April 10, and then April 2021, I hit that 2-year mark, the start date of my relationship is April 10. So that today would be the start of my relationship. So that's the relevant date for property division. Some people aren't aware of that. They think the 2 years starts from when they've hit the 2-year mark and goes on from there. Okay, so I've talked about the date that starts the relationship, and now in terms of the end date of the relationship, the triggering event is the separation date. So once you hit separation, that means that each spouse automatically has an interest in everything that is family property. And I'll talk about what is family property later on, but that is the date that triggers the right to property division. And I should also mention that the Divorce Act doesn't talk at all about property division, so these claims are only going to be made under the Family Law Act. So you don't have to worry about the Divorce Act at all here or telling clients about it for this issue. And I should also mention too, with cohabiting couples, sometimes it can be a little bit difficult to determine when people actually started living together. Sometimes, someone is spending every night at someone else's house, but they still have their own residence, or they've moved some of their stuff there, but they aren't really living there yet. Or sometimes parties are actually in a marriage-like relationship, even though they have separate residences, because perhaps they live in different cities just for practical reasons or for immigration reasons. So I can tell you that entire trials have been fought on when the relationship started. And there's a series of factors the court will look at. Did they share finances? Did they spend holidays together? Did they vacation together? Did they tell other people they were a couple? Were they planning on getting married? Were they engaged? So it can be a very complicated issue. So if you have someone in that situation, where it's not clear whether they're common law or not, you just may want to advise them that they may be a couple. They may still be in a marriage-like relationship, even if they're not living together, if they're meeting some of those factors. Okay. So that was a little bit of a side note. Limitation periods are very, very important in property division. So I'm not sure everyone knows what a limitation period is, but basically that means that it's a period that once it expires, you can no longer make a claim to court for that relief, okay? So the limitation period for property division in BC is 2 years for married spouses from the date of divorce. And to be honest, that's not really so much of an issue because divorce is often the last thing that happens in a family law dispute. After the other issues are settled, the parties will go to court and get a divorce, and it's usually not a very contentious thing. So the limitation period usually is not a big concern there. But for cohabiting couples, the limitation period for bringing a property claim is 2 years from the date of separation. So as soon as cohabiting couples who are spouses separate, the clock starts ticking. So it's really important if you have clients who come in who are thinking they may be entitled to some property division and nothing has really happened since separation, and it's been maybe a year and a half since separation, you really want to inform them of the fact that there are limitation periods, and if they can't agree, they're not going to be able to go to court if that 2-year period expires. Having said that, there is one thing that can suspend the running of the clock, so to say, the limitation period, and that is if parties are actively engaged with a family dispute resolution professional. So if they have a lawyer and they're trying to work out their differences, or if they're going to mediation, they're not simply just sitting on their hands, then that is potentially something that could stop the clock so that it keeps their claim alive for longer than the regular 2 years. Okay, so family property. Family property is a very, very broad definition. So generally, it includes all property that's owned by either party at the date of separation, including assets acquired after the date of separation with family property. So for example, if I separate from my spouse, we have a joint bank account, I take funds out of the joint bank account and buy myself a brand new Corvette because I'm having a midlife crisis, that is family property because it was bought with family property. Oh, I'll also mention, so it includes real property like houses, the family home, personal property, which could be furniture if it's expensive furniture, art, jewelry, things like that, things in a safety deposit box, corporate interests, ventures and partnerships, bank accounts, investments, RSPs, and pensions, including the Canada Pension Plan. And then I'll talk about the piece about excluded property later when I get to that. Family debt is all debt incurred by a spouse during the spousal relationship. So if I was going to school before I started living with my partner and I incurred a lot of student loans, that is my own personal debt because it's debt that I brought into the relationship. So only debt that was incurred during the relationship is going to be split between the parties. It also includes debt incurred after separation to maintain family property. So if one spouse was making mortgage payments or had other debts that came due on a line of credit, for example, that they were paying for the kids or the utilities of the house or something after separation, then that would still be family debt because it's used for the benefit of the family. So I mentioned that everything owned by the spouses at the date of separation is family property. This is the exception to that. So excluded property is all property the spouse owns when the relationship started. So if I'm getting into a relationship and I already own my own condo, then that is my excluded property because I brought it into the relationship. The thing to remember with this is that the value of the excluded property when we started living together is excluded, but the increase in value throughout the relationship is not excluded. So it can get a little bit complicated, but for example, if I am getting into a relationship, I have a condo, my condo is worth, I was going to say $100,000, but that doesn't really make sense. My condo is worth $500,000, and we were in a relationship for 5 years. 5 years from now, my condo is worth $800,000. So that $300,000 is family property because it's the amount that my property increased. Okay?
So even if there is a premarital agreement that condo always belongs to me, it doesn't make sense. I'm just telling you, there's a lot of mumbling going on. I'm just telling you what the law is under the Family Law Act. So this would apply to people who don't have an agreement. If people have a cohab agreement or a marriage agreement, of course you can agree to
basically anything you want to that is different than this act. But if people do not have that, this is what the scheme that's going to apply to them. So yeah, often we do cohab agreements for people or marriage agreements where they say, you know, I have my property, I'm bringing it into the relationship, and we want to agree that even the increase in value is still my own property if we ever separate, and that's totally fine. We do that all the time. But that's not what the family law default mechanism is. Okay, so other things. So in addition to property you brought into the relationship, other things that are excluded property are gifts, not gifts from your spouse, but gifts from third parties, inheritances, court awards. So if you get a court settlement award for some amount that's, you know, unrelated, like an insurance claim or something, or a personal injury claim, insurance payments, and property held in a trust that was contributed by someone else. Those are all things that you can claim as excluded. Now, excluded property isn't just automatic in BC. In some provinces, like Ontario, it is. Everything that you owned before the relationship is automatically your own property. But in BC, you have to make the argument that I had this before marriage, and I have documents to show that I bought this house in, you know, whatever, 5 years before we got married. So the burden is on you, the person who's claiming the property is excluded, to prove that you had it before marriage, or to prove that it was your inheritance or something like that.